Lawyers, and to a large extent doctors as well, are really bad about explaining certain terms and certain concepts to our clients and patients. We need to be more careful about that, more vigilant about making sure our clients and patients understand what's going on. Case in point, I had a deposition scheduled one time, and I sent my client a letter saying, hey, we've got a deposition coming up in your case. You need to be prepared for it. Read this little booklet that I've enclosed in this letter. My client called me up and he said, what the heck is a deposition? And I explained it to him in layman's terms. A deposition is simply a situation where you come into my office and you're sitting at a table. There's a court reporter there that's a person that takes down every word that's said. The other lawyer's there, I'm there, possibly the other party's there, and the other lawyer gets to ask you questions. You're under oath, you've raised your right hand and sworn to tell the truth, and you have to tell the truth. And that's essentially what a deposition is. So what happens if a divorce is filed, but you don't have the money to continue to survive, either because you haven't been working during the marriage or you've been working at a much lower level than your spouse? What do you do? How do you get money to survive? Well, in Tennessee, as in most states, the law provides for temporary support during the pendency of a divorce case. In Tennessee, we call it pendente litis support. It's pronounced different in different counties, depending on where you are in Tennessee. But it essentially means support pending litigation. So what you would receive is both child support if you have children and you're raising those children, and alimony, temporary alimony, during the pendency of a divorce case. And it can be for a specific amount of time, or it can be until the case is over with. And that's the more common scenario. So what you do is you petition the court after the divorce is filed, asking the court to set temporary support. And usually, if the need is there and the ability to pay is there, you'll get it. So you've been to trial on your case and you don't like the outcome. Maybe the judge gave custody of your child to the other parent and you think you should have gotten custody. Maybe the judge let evidence in that you don't think the judge should have let in, and it affects the outcome of the case. What are your options? What can you do? Well, you can file an appeal. That's really your only option. Appeal takes a long time, and it goes up to a higher court, and that court reviews the evidence that was introduced in the trial court. A lot of people think that an appellate court hears evidence again, hears the case over again. That's not what happens. All the Court of Appeals does is look at the evidence that was introduced in the trial court. They read transcripts, they'll read arguments called briefs that are prepared by the lawyers, and they'll consider all of that and see if there were any mistakes made by the judge. Usually they're not. Only about 5% of cases are reversed on appeal. Those aren't good odds. Hey, I finished up a case a couple of months ago where dad lived in Arizona and mom lived in Tennessee. And dad had filed for divorce in Arizona, but hadn't gotten service on mom in Tennessee yet. Mom filed in Tennessee and got service on dad in Arizona. But here was the big issue. The kids lived in Tennessee with mom and had lived there for about 6 months before mom filed the complaint for divorce in Tennessee. So here's what the courts did. The court in Arizona granted the divorce to dad against mom. But the issue of the children and where the children were going to live and what the visitation was going to be and child support issues, all of that had to be handled in Tennessee. So we had two separate cases, one dealing with the actual divorce, the other dealing with custody and visitation. One was in Arizona, the other was in Tennessee. We ended up working it out and getting everything done, everything signed by the judges. But that was a tough jurisdictional issue. So you want to be a lawyer? Why not? The world needs more lawyers, right? Yeah. Well, here's what you got to do if you want to be a lawyer. The first thing you got to do is you got to graduate from high school or get your GED. Then you got to go to college for 4 years. You got to get what's called a bachelor's degree, a 4-year degree from a college, usually an accredited college. Once you get that bachelor's degree, then you have to take a test called the Law School Admissions Test, LSAT. Once you take that test, then you've got to apply to law schools. You've got to send the law schools your transcript of your college. You've got to send them the LSAT results, recommendation letters, etc., and a fee for the application process. If you're accepted to law school and can pay the bill, you go to law school for 3 years. And once you get out of law school, then you've got to study for and take the bar exam for the state where you want to practice. And then, if you pass it, you get to be a lawyer.